Welcome to part 3 of a 5-part series offering professionals information about the SECURE Act, which was signed into law in December 2019. SECURE stands for Setting Every Community Up for Retirement Enhancement. Designing and drafting trusts in light of the SECURE Act. That's the subject of today's ACTEC, Trust and Estate Talk.
Welcome to ACTEC Trust and Estate Talk from the American College of Trust and Estate Counsel, a professional society of peer-elected trust and estate lawyers in the United States and around the globe. This series offers professionals best practice advice, insights, and commentary on subjects that affect our profession and clients. And now, our ACTEC fellow host with today's topic.
This is Susan Snyder, ACTEC Fellow from Chicago. The SECURE Act has reduced the period over which most people can take distributions to only 10 years, which affects the way trust and estate attorneys are going to design and draft trusts. Designing and drafting accumulation trusts, trust clauses for IRAs, and other retirement plans has changed. To give us more information on this topic, you will be hearing today from ACTEC Fellow Stephen Gorin of St. Louis, Missouri. Welcome, Steve.
As you know, the SECURE Act has reduced the period over which most people can take distributions to only 10 years, and this certainly affects the way that we're going to draft trusts. First, I'm going to spend a moment talking about the way we used to draft trusts under the old law, and then I'll talk about options available under the new law and the flexible drafting I think you should use. So, under the old law, whenever you drafted a trust to accumulate, you always had to determine the oldest possible beneficiary, and it had to be an individual. And that was very challenging and complicated in our drafting. And so we tended to use conduit trust for a lot of people. In a conduit trust, any distribution from the IRA that the trust receives must be immediately distributed out to the beneficiary. Now, of course, that doesn't let you accumulate anything inside the trust, which frustrates the purpose of trust, but it would let you use the beneficiary's life expectancy. So let's suppose you had a 40-year-old beneficiary, and then maybe they would have 35 or 40 years left on their life expectancy. So, for example, if it's 40 years left, they could take out 1/40th in the first year, 1/39th in the second year, 1/38th in the third year, etc. And so they wouldn't really be invading principal very much until they actually reached their own retirement age. So it really wasn't a big deal to have a conduit trust. And in fact, for younger people, they could take it out over 70 years. And again, for many, many, many years, it really wasn't distributing a lot out of the trust. Now, under the SECURE Act, for most beneficiaries, they can take out under a period only up to 10 years. And that period of up to only 10 years certainly doesn't let them stretch it, and it forces it out of trust. And so it's not nearly as attractive as it was under the old law. So under the new law, I think people are going to be doing a lot more drafting of accumulation trusts. So what do you have to do for an accumulation trust? So the accumulation trust needs to provide distributions only to individuals. It can be any individual. You don't have to figure out the maximum age now under the SECURE law, but only individuals. So you have to make sure that during the time that there's any assets in trust, it's only going to individuals. And then you want to plan for what happens when it's not individuals. Well, when it's not individuals, let's say it will go to maybe charities eventually, then you need to have, standing in between the trust and that charity or whoever, you have to have at least one individual who would receive outright. So your accumulation trust can last, for however long you want to have it last. But then there needs to be one individual left standing who would get it outright before it might pass to a charity or some other person who's not an individual. So we call that last person standing. So those are the two requirements: distributing during life plus an outright distribution to the last person standing. Now, that's the way any accumulation trust would be done. Now, if you have a conduit trust, then you don't have to worry about who's going to be getting it down the road, so you don't have to have that last man standing clause. Now, with an accumulation trust, you need to worry about GST planning. So generation skipping transfer tax that applies when you transfer assets to for example, grandchildren or more remote beneficiaries, and that's an extra tax that gets imposed if the assets are not included in the beneficiary's estate. So what we like to do is we like to put in a general power of appointment, so that allows the beneficiary to appoint perhaps the beneficiary's estate or the creditors. But let's suppose you limit it to creditors. Well, the creditor might be an entity, might not be an individual. Could you make a general power appointment to only creditors who are individuals? I don't know the answer. I don't know any law that says you can or you can't, but I'm just not necessarily comfortable with it. So what you might want to do is kind of have a mixture. If your assets are protected by GST exemption, it could be in an accumulation trust. If they're not protected by GST exemption, you might put it into a conduit trust, and then you can have your general power appointment, because with a conduit trust, you don't have to worry about who takes after the beneficiary dies. Now, another thing to think about is, what if you have a disabled or chronically ill individual? And for those people, they can take it out over their life expectancy. So as long as the only people who can currently receive distributions are disabled or chronically ill, you can stretch it out over their life expectancy. So that is a much better accumulation trust vehicle to use. Now, there's also, if you have a minor child, you have some significant stretches available that's listed describing other podcasts. And for those, you might want to have a conduit trust, or you might want to mix and match. You might have some that goes to a conduit trust, and we know that it was going to be spent in the beneficiary's 20s and 30s just because of the financial plan. And so you might have part of it going to the conduit trust for that person, and then part of it going to an accumulation trust. What I really like to do, though, is I like to have some flexibility built in. So under current law, and this is expected to continue under the new law, if you eliminate beneficiaries anytime before the beneficiary determination date, then the IRS will respect that and just look at the way the trust looks at the time of the beneficiary determination date. And the beneficiary determination date is September 30th of the calendar year following the calendar year in which the person dies. So what I really like to do is consider, you don't know what the IRA is going to look like when the person dies. They may spend it all during their retirement. They may spend none of it or just a little bit of it. So you don't really know. So what I really like to do is to draft clauses that will allow you to modify the trust sometime between the date of death and the beneficiary determination date. So I hope these tips have proven helpful to you, and look forward to communicating with you on future podcasts. Thank you.
Thank you, Steve, for your designing and drafting recommendations. Tune in next week for our next Secure Act topic, disabled or chronically ill beneficiaries under the Secure Act. Visit actec.org/secure-act to find additional resources.
Thank you for listening to this episode of ACTEC Trust and Estate Talk, the podcast series about wealth planning matters from the American College of Trust and Estate Counsel. To find an ACTEC lawyer near you, visit actec.org. Please subscribe to this series and leave us a rating or a review. Follow us on Facebook and Twitter at ACTEC Talk.